Martin Sharma. On behalf of the entire Board's Federalist Society, it's my pleasure to welcome you to today's event entitled Is Private Property a Lesser Constitutional Right? Speech by Mr. Stephen Eagle. Just a few things I want to mention. It's Piracy Week at the Federalist Society. On Thursday, we have a big event coming up sponsored by the John Templeton Foundation entitled Is IP Law Even Relevant Anymore? The Case for and Against Piracy. It's by, it'll have Ludwig von Mises Institute scholar Stefan Kinsella. You may know him, he's kind of a big deal in that circuit. And it should be pretty good. We'll have Indian food for you guys, and that's on Thursday. For today's event, it'll be a speech, so it's about 20 to 45 minute speech by Professor Eagle. We'll have questions and answers from the audience afterwards. I'll do, as usual, the brief introduction of our speaker, and we'll get started. Professor Stephen Eagle is a professor of law at George Mason University Law School, where he teaches property, land use regulation, and constitutional law. He's the author of the highly popular treatise entitled Regulatory Takings. He is also the author of numerous other scholarly and popular works on land use and environmental regulation and on property rights issues. Professor Eagle studied economics at the City College of New York and is a graduate of Yale Law School. He frequently lectures in continuing legal education programs and for student groups. He's the former chair of the Condemnation Law Committee of the section of the State and Local Government of the American Bar Association. He's also a member of the American Law Institute and a fellow at the American College of Real Estate Lawyers. Professor Eagle is the senior scholar at the Foundation for Research in Economics and the Environment in Bozeman, Montana. With that, please join me in welcoming Professor Stephen Eagle.
Thank you so much, Mr. Sharma, for the introduction. And it's great to be at the OSU chapter of the Federalist Society. I'm going to be speaking first about why most property professors treat property the way they do. And then I'll speak more particularly about eminent domain and regulatory takings. I know some of you are probably first-year students, and you've just been studying this, so I have a few things to say about it as well. I do talks at Federalist Society, functions at all kinds of law schools, religious law schools, other conservative law schools with all kinds of students, and liberal law schools too. I did a talk a while ago at the City University of New York chapter, and of course New York City has lots of law schools, and this law school was established precisely to represent the public interest, which presumably other lawyers do not do. So the officers of the chapter spent weeks talking with property teachers there, trying to get someone to debate me, because I enjoy debates. And they never got their emails responded to, they never got their phone calls returned. The chapter cornered one property teacher in a hallway and asked point blank, why wouldn't that person debate me or come to speak? And the answer was, well, she didn't want to appear with me because that would legitimize my visit. Well, I've been called illegitimate before, I've been called worse even, and it's not that I take it personally, and it's not that I expect you to be interested in my travails, or even the fact that Federalist Society speakers are not always universally welcomed. The point I want to call attention to in all of this is the particular notion that law faculty tend to have that we legitimize things. That we take things that are questionable perhaps, or things that are indeterminate, and by our endorsement we make them legitimate things. Now, legitimation in fact has a very particular role in law. If someone were in the natural sciences, or in mathematics, or in philosophy, defending a proposition on the grounds that people have believed it for a long time, or that leaders in the field believe it, would just get you laughed out of the room. And it counts for nothing. The only thing that counts is pure logic and reason and empirical study. In law, on the other hand, is different. Former Dean Anthony Croman of the Yale Law School wrote, "The past is, for lawyers and judges, a repository not just of information, but of value, with the power to confer legitimacy on actions in the present, and though its power to do so is not limitless, neither is it non-existent." And, we shouldn't forget, the common law itself is not based on some formula springing from the head of Zeus, or from the Emperor Justinian, or Napoleon. We don't have that kind of civil law tradition where the leader sets the rules logically. The common law tradition is very, very different. As the U.S. Court of Claims, Federal Claims declared, the Anglo-American case precedent is literally made up of thousands of cases defining property rights over the better part of a millennium. The legal task is very unlike legislative policy making because judicial decision making builds historically and logically upon past precedent in narrow cases and controversies, rather than current general exigencies or sweeping political mandates. The common law grows through accretion, through lots of small steps. When Oliver Wendell Holmes famously wrote that the life of the law has not been logic, it has been experience, he was writing from sad knowledge of how people actually behave. And this was the very same impulse that led James Madison in Federalist 51 to write, "But what is government itself but the greatest of all reflections on human nature? If men were angels, no government would be necessary." This is a very almost contradictory thought. We have to have government because we really are not capable fully of governing ourselves. That we are trying to, through checks and balances and in other ways, cabin our worst impulses and allow our best ones to show through. Now, both Holmes and the common law judges were reflecting on the fact from a Burkean tradition, from a notion Edmund Burke had first stated that almost all people are too fallible to operate in a complex society through logic and analysis, and that they operate, quote, not primarily through reasoning, but through adherence to prescriptive roles, customs, and habits, continually adjusted to the messy demands of day-to-day living. And this is why conservatives have particular respect for the past, not because any individual person in the past was smarter or more perceptive or more able than we, but rather it's too difficult for any one of us to get our arms around everything that really has to be known, and so we take as a guide those things which seem to have worked in the past, and we try to build them and adopt to them. And of course, we start out with the notion that we own ourselves. We're our own people. We establish government to protect our rights. As John Locke famously put it in the second treatise, lives, liberties, and estates, what I call by the general name property. And of course, property is simply one very small subset of what he called property. Back in the 18th century, property had a somewhat different meaning than it does now. A meaning currently captured only in the usage of, for instance, talking about the properties of a chemical element, the properties of a substance. When we ask what something's properties are, we say what are the things intrinsic to it and characteristic of it. And one property of a full and free member of society is the right to own property, as we think of it in terms of things. And, but this is one tradition. There's another tradition that the Lockean tradition constantly has to battle with. And this is the tradition followed by the modern disciples of Thomas Hobbes. In Hobbes' 1651 book, Leviathan, he wrote that the chaos of a state of nature results in the in the war of every man against every man. In a state of anarchy, it's every man for himself. Every person has to protect his or her own family, his or her own possessions. And this is intolerable. You can't really live this way. And so he said, the life of man, brutish, solitary, poor, nasty, short. The life of man is really a terrible thing under those conditions. So even if our sovereign is not going to be a very nice person and is going to demand the lion's share of society's produce for himself, having that sovereign, Hobbes said, is far better than the alternative. So Hobbes says finally, to sum it up, it is not wisdom but authority that makes the law. So Locke says we have law to protect our existing rights. Hobbes says what the sovereign says goes. And those are two different views that percolate down to modern day and that very much inform what people learn in law school about property. I'm sure all of you have taken the basic course in property. You've learned that you should not think about property, as the Supreme Court once put it, as, quote, in its vulgar and untechnical sense of the physical thing, with respect to which the citizen exercises rights recognized by law. The court then spoke about property's, quote, more accurate sense to denote the group of rights inhering in the citizen's relation to the physical thing as the right to possess, use, and dispose of it. So you learn from the very first week of law school you're not supposed to think of the property as being the object. You're supposed to think of property as your relationship with other people regarding objects. Technically speaking, this is the proper and the more sophisticated way to look at it. And from that, we go on to learn about a bundle of sticks, and we learn that, in most classes, we learn that government decides what sticks are in what bundle. And the bundle of sticks approach, to be sure, is very, very useful. It enables us to speak about situations where a physical thing has multiple owners. For instance, you can have an apartment. The apartment can have a tenant who has the current right of possession, a landlord who has the future right of possession, people who have easements, people who have, a lender may have a mortgage, enabling that lender to take over ownership should the loan not be paid. So this is a very useful way of looking at things. And it may be hard for you to imagine, but before the beginning of the 20th century, even the largest and most complex industries in the United States got by with nothing more than basic leases, fee simple, mortgages, and easements. The kind of complicated slicing and dicing of financial and possessory rights that grew like topsy since World War II was really totally unknown to people earlier. So we have now, of course, a multiplicity of rights. Think about a regional shopping center, 3 or 4 major department stores, lots of little stores, kiosks, parking, entertainment, food. All of these things are held together by an array of contractual relationships, so that there are thousands of different property rights in a modern shopping center. And so Property, as we know it, has become fractionated into all these rights, and, of course, we found most recently, to our chagrin, as it made the headlines, that these rights tended to be collateral for mortgages of various kinds, and slices of these mortgages called tranches were sold to people all over the world. So unsuspecting people in distant countries and cities wind up owning tiny slices of investments somewhere. So it becomes really, technically speaking, quite a multitude of things we are talking about. Unfortunately, I think that many people in my business are sufficiently enamored with the technical sophistication of dealing with all these rights and claims and talking about how to administer them, how to litigate them, that we tend to lose sight of the traditional meaning of property and why it's so important. Professor Thomas Gray's monograph, The Disintegration of Property, is seminal in the field, and it asserted that the term private property has no uniform meaning in ordinary speech, and that the property referent has, well, no integrity. That is to say, disintegration, integer one, disintegration is something that goes away from being one. It's no accident that another word that has the same root is the word integrity. So, as property crumbles, as they would say, property loses its integrity and loses its meaning. One of my former colleagues, Francesco Parisi, wrote that entropy in property, causes property to spiral through a one-directional inertia that fragments property, while reunifying fragmented property rights usually involves transactions and strategic costs higher than those incurred in the original deal. So picture, if you will, property sitting on a wall, and like Humpty Dumpty taking a great ball, and we can't put it back together again. Property is just shattered. So property is doomed to go into smaller and smaller pieces and become less and less useful. Well, who's going to salvage the situation? Well, of course, it's only one party that can do that. The government is going to come in and salvage the situation. So the argument goes. And so when we talk about bundle of sticks, you have to be very aware that implicit in this terminology is the idea that there is a kind of a normative element of this lurking just beneath the surface. And the normative element is that there is no foundation or unity in the term property, and therefore courts, hopefully guided by we wise scholars, courts should be able to put together pieces of it as they deem best for society's purposes. So these bundles of sticks then become ad hoc temporizations. Good for this trip only, maybe good for a few things, but there's no underlying meaning to the concept anymore. One application of this that some of you might have read about is Professor Michael Heller's Tragedy of the Anti-Commons. Tragedy of the Anti-Commons, which is a wonderful title because it builds on all kinds of misunderstandings. First, take the commons. Some of you may be familiar with Garrett Hart, and I'm sure your property casebooks have this back in the notes somewhere if you didn't discuss it in class. Garrett Hart had this idea that if you have land which is open to everybody, everyone's going to abuse it. People are going to do too much. They're going to basically ruin it. They're going to pasture too many cattle on it. They're going to destroy all the green stuff so that nothing can grow, and it's going to be bad for everybody. This is the tragedy. Unfortunately, Hart is not discussing a real commons. Hart is discussing an open access regime. An open access regime is one where literally anybody is free to come in. And yes, Hardin is right. In a world where anybody is free to come in, then people are going to waste it. And this is not a new insight to Hardin. I traced it back as far as, and I'm sure he didn't originate it even, Aristotle, who observed that if everybody owns something, then no one owns it. But do you want to see a real live commons? Go to your homeowners association swimming pool. Go to a private club. You'll find a sign on the wall saying members only. Only people who are part of the group can use the facilities. The facilities are in common to them. If you're on the outside and it says, show your membership card, and you're not a member, as far as you are concerned, it makes no difference whether one person owns what's inside or 200 people own what's inside. All you know is that you don't own it. That's the important thing. And of course, the membership is small enough and is self-policing so that they can deal with this thing to make it the most amenable to their common use. So the problem with the tragedy of the commons is not that there's too much property rights, there's not enough property. Heller misunderstood this. Heller was writing about storefronts in Moscow, and he observed that these storefronts were empty because so many people had a say in how you could use it that no one could use it. You had to bribe or pay or negotiate with so many people to be able just to open a store that it wasn't worth anyone's while. Well, Heller was right, but the big problem there is that this was not something that flowed naturally from existing common law notions of property. Rather, all these people got these rights as a result of shards of rights flying in the air as the Soviet Union imploded. Totally unnatural situation. When in the real world, people have different roles and they change roles. You have one role in one kind of deal, another role in a different deal, and there's a natural impulse to work together to make those roles compatible, which does not exist in the Hellerian world of Moscow property. And by the way, and I'll talk about this a little more later in my talk, this is exactly the impetus for what happened in Keeler versus City of New London. The whole notion that if there are these small parcels, it must be because they're fragments, we have to put all this together, make it viable for the community, we'll take all these little parcels from all these little people and throw them off the land, and the state will redevelop it with some trusty developer, and that will be good. That was the notion behind Keeler, and as we'll talk about, it didn't work very well there, and it doesn't usually work very well. So, and this all stems from this concept of a lack of understanding of what property is, and a notion that property is simply a fractionated bundle. Now, having chastised the left on this, I have to say, in all fairness, that the law and economics folks with whom I associate do something similar. Law and economics people tend to talk about not property and not contracts either. They conflate those two things into command over resources. Well, you know, command over resources may work in a practical world, again, if you're dealing with a given situation, if you're doing economic modeling, but there is a big difference between property and contract. Two people can get together and have whatever contract they want, so long as it is legal. They can have a short contract, they can have a detailed contract, they can have a specific or vague contract, or a whimsical or very practical contract. It is up to them. The law simply enforces their bargain. They make the bargain however they like. Property is very different. Property rights are in rem. They're against the whole world. If you have property rights, everyone is expected to know it. People who are not party to what's in your mind or what you've done with other people. So property rights have to be respected by everyone. That's why they're simpler and why they tend to follow uniform patterns. Precisely because we all have to understand what they mean. So, property is really every person's private perch. It's a respite from the world. It's an area in which a person can exercise autonomy. We each decorate our homes. We even put up our little pictures in our little cubicles at work to identify these things as being ours, to imbue them with their own personality. The Soviet Union had those terrible gulags you've heard about, those slave labor camps in Siberia. Relatively few people were sent to them. Since the state owned all the housing, and since the state was the only permitted employer, for most people, it was enough to keep them in line for them to know that if they spoke out of turn, they would lose their jobs or lose their apartment. Where the state has a monopoly and where there is no private property, then the notion of individual liberty very, very quickly goes by the boards because you're depending upon the state for your largesse. Then why don't we recognize private property as important as it is? Why do we, in law schools, tend to focus on these little bundles and elegant descriptions of the tiny fractional parts of property? Partly because we can. Coming up with novel theories of property rights as well as other things is fun, at least for some people. It's law professors' ways of doing pirouettes. While you see ice skaters doing pirouettes, law professors do it by coming up with novel forms of rights. So we have fun doing that. And of course, if one is an up-and-coming theorist and says something which is so much against common sense that no one had thought of it before, one is even more celebrated. So, of course, we constantly are in the business of churning out new ways of looking at things. A little sociology helps, too. I just was reading a paper by Professor Jeffrey Lipshaw on metaphor, models, and meanings. And he says, now you've got to set your mind here, this is a little bit of sociology. A closed system of language and classification is another way of expressing what the legal sociologist Gunther Tubner called law's epistemic trap. Law as a social institution develops its own models or constructs of reality. Its cognitive operations construct idiosyncratic images of reality and move them away from the world constructions of everyday life and from those of scientific discourse. That's sociology. In plain English, like teenagers or people wanting admission to the in-group in any crowd, team, profession, neighborhood, we want to use the vocabulary that's going to make us accepted. If we use an esoteric vocabulary, then we become, or try to become, associated with the in-crowd of people who are developing new theories. And so we have, through this kind of theoretical modeling and through use of this bundle of sticks metaphor, which is certainly helpful in many cases, we become desensitized to the fact that property has a more fundamental meaning. Now, certainly, surgeons become desensitized to the sight of blood, thankfully. We don't want surgeons to fall apart whenever they do operations. So people in their professional lives, to a certain extent, have to be able to do things without immediately embracing their underlying significance. Same with lawyers. In our transactional practice, we certainly don't want to run afoul of these little technicalities we have to know. But that shouldn't cause us to lose track of the larger meaning, which is property as a bulwark for individual autonomy and liberty. Without it, we would be dependent, as I said, on our political rulers, and we would not have independent protection, independent livelihood, and it would be a very, very different kind of society. When Justice O'Connor, in the Kelo case, talked about the fact that once eminent domain goes beyond its traditional role of taking, and the Constitution does provide, obviously, implicitly, that the Congress has a right to take private property. But remember, eminent domain, of course, was established traditionally for the purpose of use by the public, use by the government, or more recently, use by regulated companies very heavily policed and regulated by the government, such as common carriers. Once you go beyond that, once you allow people to take land from other people because it suits their needs, because we say that it improves society, there's no cabining at that point. Everything is up for grabs at that point. When Justice O'Connor said that every Motel 6 is in danger of becoming a Ritz-Carlton, she was very criticized for that by people who were extremely jealous of the rhetorical power of that remark. But that's the way it is. That's the truth. Now, when I've debated this topic, the people I've debated with have talked about the fact that, well, property is not absolute. I had someone recently talk at some length in rebuttal about property not being an absolute value. You know, when Blackstone says absolute and despotic dominion, that's not really true. Well, of course it's not really true. Blackstone knew that was not really true. I'm not saying it's true. Property is not an absolute value. And one of the difficult things about our Constitution and about our system of government is we have values that at the margins present close cases. But we have to remember what the fundamental rights we're trying to protect are. So property is one of those fundamental things. Now the common law nuisance seems like it's a control on property, but actually common law nuisance protects property. Common law nuisance says that your use of your property is free of your neighbor's use of their property that unreasonably would interfere with you. So that's really pro-property rights. We went from that, common law nuisance, to zoning. And zoning is a kind of prophylactic device that tries in advance to head off clashes by preventing nuisance, things like nuisance, and by saying this goes here, this goes there. That worked tolerably well. Now, however, localities, partly to raise money, partly because they think they know better than other people, are trying to fine-tune the notion of property so that everyone's property not only should not be used in a way that interferes with others, but should be used in a way to give the most affirmative advantage to society as a whole. You've read the Penn Central case. Go back and read Chief Justice Charles Breitel's opinion in Penn Central for the New York Court of Appeals before it got to the U.S. Supreme Court. He says this railroad terminal is very, very valuable because there are a lot of valuable businesses around it, people who invested a lot of money in the neighborhood, governments invested money in the neighborhood, and therefore it doesn't belong to the railroad. It belongs to, in effect, the government. So anything that isn't totally tied down belongs to the government. And if you don't have a fundamental understanding of the importance of what property is, and you rely just on this bundle of sticks notion, your view is simply going to be instrumental, and if your view is instrumental, it's not tethered to anything at all, and if it's not tethered to anything at all, individual liberty is what goes by the boards. Thank you. Happy to entertain all your questions. I think that's the most fun part of the Federalist Society programs. Question? Yes.
Does what you're saying kind of go against the historical reality of how property was ceded to?
I'm sorry, historical reality of what?
How property was ceded to certain individuals. I mean, the government essentially gave property to all, since we were spending much for even in Alaska, places like that. I mean, does that factor into the equation at all? So
let me see if I follow. Government, in a sense, takes over new territories.
Well, they acquired property and they essentially protected property, and then individuals were able to purchase it. Is that a factor at all?
Okay, well, there's a distinction in law between sovereignty and property. One of the most disgraceful instances in American constitutional law was the Johnson versus McIntosh case, which you may have read in the basic property course, where Chief Justice Marshall said that basically He said it is a particular conceit that Europeans came and discovered America and the people already living there. But this is our law. And those Indian tribes did not have property rights as we understand them, and therefore they're thrown out. Now, Marshall is our great Chief Justice, not because he always did the right thing, but because he knew how far he could push the Supreme Court's power and pushed it that far and no further. He knew in Johnson versus McIntosh, political forces just would not, at that time, allow a decision to the contrary to stick. And indeed, remember, President Andrew Jackson later sent the Cherokees out of Georgia on this terrible trail of tears, where many of them died. So government, by taking over new territory, has sovereignty. And again, if you take a view that government is established for the people, government then is the body, is the executive that gets new territory for the benefit of not the government but the people. And this is divvied up, and it's true the government issues the letters patent, but the fact that the government had acquired that land no more necessarily gives the government continuing dominion over that land than it gives the government continuing dominion to run any other aspect of your life on that land. Could government say, for instance, having established the state of Ohio, that in Ohio there are no rights of free speech because this was federal land and this is what the federal government says. If you have a free people, I think that the notion that government can control the private aspects of life because of its sovereign power is an extension of rights of government that certainly wasn't intended in our Constitution, and I really don't think we want to go down that road. Hope that answers your question. Any questions? Yeah.
I was curious your view about, you know, kind of a stronger private property right, and what you think of, you know, Kelo seems to have, the dissent in Kelo, which is kind of caught on the states, basically draws a line at economic development. You can't take land, you know, solely for economic development, but they kind of upheld several other cases saying, you know, essentially for, you know, to break up land oligopolies, or, you know, endorse the idea that, you know, even if you're, you know, several lots are being well maintained, the government can still take them, you know, if the area is bad. And I was just curious how far you think we've gotten away.
Can government take well-maintained areas in an area which otherwise is blighted, let's say? Well, the Supreme Court answered that question yes in a case called Berman versus Parker, where the Supreme Court had one sound department store building, and Justice Douglas said that once government has a legitimate object, which is to say eradication of slums, the way in which it pursues that object is up to the government. Notice by saying that, in effect, he's taking any independent significance away from the Takings Clause. You don't have an independent Takings Clause. Why do we have a Takings Clause? Well, if government takes your property and pays you fair market value, is that going to really satisfy you? Not unless you had your property up for sale already. Because if you don't have your property up for sale, it's because that property is worth more to you than it is to other people. You may have grown up there, your kids grew up there, you have idiosyncratic comfort with that land, your business may be there, your customers may look for you there, you may have customized the premises there. So almost everyone has personal value in real estate that is destroyed when government takes private property. So takings are very wasteful, even if they are fully compensated. And of course, that's not always the case. You know, just last year, Columbia, I just was talking a few weeks ago at Fordham Law School, presenting a paper on eminent domain. Fordham Law School, by the way, is built on land it's on Lincoln Center in New York. It's built on land condemned from its former owners and transferred to Fordham University. Columbia University now is taken over a big chunk of West Harlem. from its owners, something that the New York courts have endorsed, and I'll talk about that in a second, and something which was applauded by the New York Times, which said this is absolutely the correct kind of decision. Oh, did I tell you that the New York Times building is put up on land, condemned, and taken from other people so that the New York Times Company could have it? And that the New York Times Company developer in that project was Bruce Radner, who was the same person who was the developer of the Atlantic Yards project, which is very heavily contested, and which the New York Court of Appeals thought was a valid condemnation, and which the New York Times editorially endorsed. All these folks are in business together. One hand washes the other. The problem with revitalization takings, totally apart from the diminution of value of property rights and loss of the existing owners, is we are building a whole new construct of crony capitalism. Who are government redevelopment officials going to trust and want to work closely with in their projects? Well, people that they already know. Judge Abner Mikva, who served, was in the U.S. Congress and on the Federal Court of Appeals for the D.C. Circuit, and later was counsel to President Clinton, relates that when he was an idealistic young man, he wanted to volunteer to work for Adlai Stevenson campaign, so he went to his local ward alderman in Chicago and said, I want to volunteer. And the alderman, of course, looked at him and said, who sent you? And Mikva said, well, no one sent me, I just came to volunteer, I really believe in all this. And the alderman said, we don't want nobody that nobody sent. Well, of course we don't want nobody that nobody sent, because we don't want anyone who isn't in our group, who isn't to be trusted politically, who isn't in a group of people who do favors for each other. I don't know exactly what the parameters of those favors are, but the sad part of it is, legally speaking, it is almost impossible to find out. In the Columbia case, the Court of Appeals simply said, the New York Court of Appeals simply said that the New York Redevelopment Agency established an administrative record showing that there was public use in taking over a swath of West Harlem to transfer to the university. The fact that the university came up with the idea to begin with and paid for a development, paid for a blight study, and the blight study showed blight, and the state of New York conveniently then condemned the land to turn it over to Columbia University. Compare that with the protections promised in the Kelo case, which talked about really looking into things. That's okay, because the administrative record prevails if there is any support for it whatsoever. If there is simply a logical basis for finding some validity to it, the courts are not in the business of checking it out. And under the United States Supreme Court's Twombly case, there has to be not only a logical basis for claiming favoritism, it has to be plausible. How do you know if it's plausible? You know if it's plausible by getting evidence. How do you get evidence? You get evidence by doing discovery. How can you do discovery? Only if you have a plausible case to begin with, Twombly says. So, in short, this kind of crony capitalist scheme can grow. The insiders all work with each other. None of them are going to be stupid enough to publish anything incriminating. We don't have the ability under the Twombly case to dig into it and find out what really happened, and so the process steamrolls and grows on itself.
You talked a bit about crony capitalism. I was wondering if you could talk maybe a bit about. I was wondering if you could talk a bit about antitrust law. It seems like in that case the government is sort of saying to a private business owner, "Your business is too successful. We have to break you up." Could a more rigorous defense of private property rights be used to defend against antitrust?
Well, I'm speaking a little out of license here because I am not an antitrust expert. I do know that the Sherman Act says that we can't have a conspiracy, a contract or conspiracy against trade. Of course, any contract really is a conspiracy in the sense that any contract, by definition, binds the parties in the future so that the parties are not free to negotiate with other people. So therefore, every contract creates a monopoly, so to speak. If you're the contractual buyer of a resource, you have a monopoly of that resource. So the Supreme Court rather quickly figured out, well, wait a minute, we can't just do that. Oh, well, no, we have to apply a rule of reason. And the rule of reason says, yeah, we'll look and see if the contract is reasonable. Okay. Well, of course, the problem is, why do we have antitrust law? This is something that Robert Bork was a pioneer in. The notion of, there are two possible reasons why we have antitrust law. One is to protect consumers, another is to protect existing businesses. And it turns out that a lot of the protection supplied by antitrust law was really to existing businesses. We don't want businesses to be threatened by those who might be more successful and might have grown, even if the reason for that is, as you pointed out, that the public prefers their business to do business with than the other. This comes up a lot in property law, for instance, especially with things like big box stores. Should a community allow in a big box retailer? The state of Vermont, until very recently, had 0 Walmarts. New York City has 0 Walmarts. Why? Because they have legislation that practically precludes them. The notion is you want to protect the existing downtown business district. A healthy central business district, the argument goes, is important to the community. These are the people who support Little League. These are the merchants who are the core of the local business community. And so we don't allow in competition, which is disliked and derided by everybody except the low and moderate and middle income consumers who would love to shop there. So you find that people cross borders to go to Walmart, for instance, in another jurisdiction. And this is true of many areas of life. For instance, the bar has been concerned about the fact that as you get more and more of a centralization of finance, local bars, which had lawyers who specialized in sophisticated corporate transactions, no longer find that kind of activity as prevalent. So this is something that goes just beyond consumer law. And it is something that is really a very broad topic about whether we have collective rights, the people should be protected against Walmart's practices, or whether we have individual rights, that people should be able to shop at the stores they like best.
All right, with that, we'll sum up the event. Please join me in a round of applause for speaking today.